Welcome to Inside the Courtroom by LiveLaw, a segment where you get the fastest account of what happened in India's most important hearings, beyond the headlines and into the arguments themselves. So for today, day 15 of the Sabarimala reference, and it looks like it is nearing a close as the 9-judge bench continued this marathon of a hearing with tomorrow being its last day. Advocate Mohan Gopal opened by taking the bench back to August 1947, when Dr. Ambedkar submitted a proposal to the subcommittee on fundamental rights containing the right to religion. His argument was that the freedom of conscience at the heart of Article 25 Clause 1 includes the freedom to not be bound by religious instructions, including instructions about who may or may not enter a place of worship. He pressed with a question that went to the root of the reference. Who exactly represents a religion? Is it certain sections born into privilege within that religion? Many people, he argued, did not voluntarily join. They were, in his words, not subsumed but consumed by religion. Justice Nagratna interjected with an observation that has run through this entire hearing, that Hinduism is a way of life, not necessarily a system of rituals, and that nobody can come in the way of a person's private faith. Now, as you can see on the text to my right, Advocate Prashant Padmanabhan made an argument on the purification ceremony conducted by the Tantri after women entered the Sabarimala temple following the 2018 judgment. He submitted that such a ceremony is a direct violation of the civil rights of those women. Another advocate made a structural argument of the entire reference, that Article 26's power to manage religious affairs is itself a form of non-legislative law. And under Article 13 of the Constitution, any law inconsistent with Part 3, the Fundamental Rights chapter, is void. Parliament and state legislatures are subject to Article 13 when they legislate, and a religious denomination, he argued, cannot be granted immunity that even the Parliament does not enjoy. In rejoinder submissions, Solicitor General Tushar Mehta proposed inverting the sequence of the essential religious practice test. As you can see according to the text on my left, he argued that instead of asking first whether something is a religious practice and then whether it is essential, the real question should be, is the practice in question against public order, health, or morality? And if yes, does Article 25 Clause 1 apply then? He argued that the Ayappans qualify as a religious denomination, and in the Indian constitutional scheme, a person can be a member of more than one denomination simultaneously. On reforms, the Solicitor General was emphatic. Courts cannot be reformists. The Constitution has left religious reform to the legislature, and when reform comes through legislation, its acceptability is far wider than when the judiciary intervenes. Justice Bagchi pushed back on that too, asking whether the majority's acceptance of a practice can ever be the constitutional test. Article 25, he noted, uses the words all equally and freely. All persons have an equal right, irrespective of numbers. The Chief Justice of India added that Article 25 Clause 1 is religiously neutral, and Article 25 Clause 2 is not, because it specifically mentions Hindus. Senior advocate Abhishek Manu Singhvi then drew a distinction that may prove important to the final judgment, that Article 25 2b, which deals with throwing open Hindu temples of public character, governs entry, while Article 26 governs management. Entry and management are two different things. Justice Nagratna's response captured this unanswered tension of the entire reference. What is the meaning of entry when you're asked to stand in the corner? For the detailed report, head over to livelaw.in, where you'll find previous days' hearings reports too. This has been Inside the Courtroom. We'll see you next whenever there is an important hearing you need to know about.